3 instances of unreasonable restrictions on freedom of profession, occupation, trade or business. 1. In Chintaman Rao vs. State of Madhya Pradesh, AIR 1955, law authorized the government to prohibit all persons residing in certain areas from engaging themselves in the manufacture of biri during the agricultural season. The object of the law was to provide adequate labor for agricultural purposes in biri-making areas. The Supreme Court held the law invalid as it imposed unreasonable restriction on the biri-making business of the area. The act is much in excess of the object which the law seeks to achieve. It not only compels those who are engaged in agricultural work from taking other vocation but also prohibits persons such as infirm, disabled, old women and children incapable of working as agricultural laborers from engaging themselves in the business of biri making and thus earning their livelihood. Hence it was arbitrary and wholly unreasonable. A law or order which gives arbitrary powers to the government and its officials to grant, refuse or cancel a license without assigning any reason and without giving any opportunity to the applicant to be heard, impose unreasonable restriction on the right of the citizens to carry on any profession, trade or business. 2. Thus in Dwarka Prasad vs. State of U.P. AIR 1954, the UP Coal Control Order, 1953, required a person to take a license for stocking, selling or storing for sale of coal. Under the order, the licensing authority, the district magistrate, may grant, refuse to grant, or refuses to renew a license and may suspend, cancel, revoke or modify any license on any terms thereof. The court held the order invalid on the ground that it gave unrestricted discretionary power to the licensing authority who could grant, refuse or cancel licenses in any way he liked. There was nothing in the order which could check him in arbitrarily exercising his powers. Any uncontrolled, arbitrary administrative direction to restrict a citizen's right in respect of trade, business, and industry cannot be permitted, as it would be imposing an unreasonable restriction outside the scope of Clause 6 of Article 19. 3. Inod Sugar Mills Limited vs. Union of India, AIR 1970, the government issued a sugar control order under the Essential Commodities Act, 1955, releasing sugar for sale in open market and allowed the sugar company for disposal of sugar within 26 days. Due to non-availability of railway wagons, sugar could not be disposed of within 26 days. The company applied for the extension of time, which was refused by the government. The question for consideration in the present case was whether the central government was justified in refusing extension of time to the appellants to clear sugar released in the open market. The Supreme Court held that the period of 26 days could not be considered as reasonable in view of the fact that the sugar would have to be sent out of state in which it was produced and transported through railway. The restrictions imposed on the appellants were, therefore, unreasonable. The court said that the right to trade is a guaranteed freedom which can be restricted only by law and not by exclusive order. Accordingly, it was held that it is not only the law restricting the freedom which should be reasonable, but the orders made on the basis of that law should also be reasonable.